All right. Yes, Deborah Bunkley will talk about the League of Women Voters Detroit.
Hello, as you know now, my name is Deborah, and I'm the communications director for the Detroit League of Women Voters, Hamtramck and Highland Park. Everyone should know that, we've been in Detroit since 1919, and women got the right to vote in 1920. But with that being said, I want to bring everyone's attention to the upcoming primary and the elections that are coming up with the mayor of Detroit, which is huge, and the city council, and apparently a police commissioner. So please encourage your people, everybody to vote in the primaries and register to vote. And thank you so much for the library for having us.
I finally got the captions up. So we have been doing this since September of 2020, and we've had a good partnership. I would like to introduce our speaker tonight, Mark Brewer, a distinguished personal injury attorney at Goodman Acker, PC. He's proud to say that he graduated from Mount Clemens High School. He earned an AB with honors from Harvard College and a JD from Stanford University Law School, where he served on the law review. He has had a remarkable legal career, which is detailed in his bio on the Goodman Acker website. In 1995, he was elected chair of the Michigan Democratic Party. He held that position until 2013, the longest tenure in Michigan Democratic Party history. At the same time, he served as a member of the Democratic National Committee. From 2005 to 2009, he presided as president of the Association of State Democratic Chairs. He has also served as delegate to 5 Democratic National Conventions, chairing the Michigan delegation each time. He has his roots in a family of union members, farmers, and military veterans. Then these roots inform his legal practice, which is primarily focused on union side labor, election, campaign finance, and nonprofit law. He's been a pivotal figure in numerous election cases since the 1980s, spanning issues such as redistricting, presidential primaries, recalls, and voting rights. His expertise extends to drafting ordinances, statutes, and state constitutional amendments in areas ranging from campaign finance to ethics reform. He has a podcast with former executive director of the Michigan Democratic Party, Jeff Timmer. Episodes are released each week. It's called A Republic If You Can Keep It. It features an insider's analysis of Michigan's political and social climate, as well as Michigan's impact on national politics. Tonight, he is going to share the fruits of his work on petitions and petition drives to help us better design and implement petitions. I'm sure that everyone in this seminar is aware of the issues that have torpedoed various petitions in recent years, sometimes well after signatures were collected. I would like right now to introduce Mark Brewer.
Say one thing, Mark. I'm so sorry to interrupt, but I feel like I need to clarify, because Deborah usually does this, that we are non-partisan, the league is. And Mark has worked with us many times at the league in a way that is nonpartisan. So I just want you to say, he's obviously been very involved in the Democratic Party and still is, But on this show and with the league, he is always nonpartisan. So I appreciate that. And Mark,
Thank you
sorry
for
to
that
interrupt.
clarification.
And
His
if
political
I may,
history is
since,
partly partisan.
if I may, since Cheryl decided to bring my name back up, Mark is also in the forefront of the league when we've had, I think I met him when he was in the U.S. District Court downtown when they were trying the redistricting case, and I'd never been in the building. And to go in there, I had to wear my cool league hat. And just you're just a really great human. And thank you so much for being in the face of the league when we're doing what we do is nonpartisan. And please talk.
Well, thank you very much. First for the invitation. I'm always honored to speak to league members around the state. Jennifer, that was an exceedingly kind introduction, so thank you very much for that. And it has been a great honor for me to represent the league in a number of matters, including the redistricting trial, but a number of other cases as well. And tonight I am presenting in a nonpartisan fashion. This is about the process of ballot questions in Michigan. And so there's no partisanship involved at all. We're going to go through the process, and then time permitting and my host permitting, I'll be glad to answer questions about the process. So with that, we do have a PowerPoint presentation, which I hope we can post on the screen, and I'll work my way through it.
I just shared this. Why can't I now? Apologies for the delay.
There we go. I hope it's readable to everybody. People are muted, so I'm not sure if it is readable. I hope it is.
Yes, it is readable, I think. Does anybody else have trouble? I don't know. Do you need it a little larger or not? Well, this looks pretty good to me. What do others, if you don't think it's that way, please put something in the chat. Well, no one's put anything in. So
I'm not seeing anything in the chat.
Okay, that's great. So I think we're good to go. So let me try to give you an overview, and then we'll work our way through the PowerPoint. And I think I'd like to save questions for the end. So if you can either put your questions in the chat or just hold them till the end, we'll try to answer as many as we can. In terms of the big picture, Michigan is really blessed as a state. We have had various forms of direct democracy in Michigan for over a century. Direct democracy includes the right to recall, which we're not going to talk about tonight, but also includes the right to put proposals on the statewide ballot. And tonight we're going to talk about the statewide ballot proposal process. Many counties.
Excuse me, Mark.
Yes.
I can't pull it up. It's trying to have me in Acrobat Pro.
Okay.
I was able to share before. See if I can pull this up.
somebody is suggesting if you hit, oh, I just missed that.
No, I
Chad.
think I finally got it.
Okay.
I haven't tried to screen share while running the program before.
I think it's back up. I can see it.
Yes.
Great. So again, we're not going to talk about local ballot questions tonight. They are available on a limited basis at the county and certainly at the city level. Sometimes the process is similar to what we're gonna talk about tonight, sometimes it's not. But we're gonna focus tonight on the statewide ballot proposal process. So I want to start with an overview of the types of ballot proposals which are available at the statewide level. And there are three which are available. The first is an initiative to create new or amend existing legislation, sometimes called a statutory initiative. The signatures that are required for this, and these signature requirements change from cycle to cycle. They're based on a percentage of the turnout in the governor's race. But for this cycle, as you can see from the PowerPoint, in order to qualify an initiative for the ballot, you would need at least 356,958 valid signatures. And for reasons we'll talk about shortly, you would want to file significantly more than that, probably 35 to 40% at least, for a couple of reasons. Inevitably, signatures are going to be invalid. You know, people are going to be registered, claim they're registered when they're not, and there are going to be other mistakes. And also, too, particularly more recently, we've developed a very aggressive culture in the state of challenging signatures by opponents of proposals. So in order to anticipate that, you would also want a cushion, as we've come to call it, of signatures well in excess of the minimum required. So that's the first type of ballot proposal, a statutory initiative. The second is an initiative to amend the state constitution. This requires more signatures. This cycle, it's 446,198 valid signatures plus a cushion. And finally, we also allow in Michigan a referendum on legislation that has been passed by the legislature and signed by the governor, simply referred to often as a referendum. And this is basically ask the voters whether they approve of or disapprove of a piece of legislation, up or down in its entirety. This cycle, putting such a proposal on the ballot would require 223,099 valid signatures plus a cushion. So those are three basic types. And the signature requirements for this cycle, this 2-year cycle, to get them on the ballot. There are also filing deadlines for these. And in Michigan, all of these proposals go on the general election ballot in the even year. Only the legislature can put a proposal on at other times of the election cycle. But for citizens, for direct democracy proposals, they only go on the ballot in the general election in the even year. And so these filing deadlines for these signatures are tied to that general election. For example, for a statutory initiative, the filing deadline is May 27th of next year. Now, that's the deadline. People can file earlier if they choose, but the deadline in order to get on the 2026 November ballot is May 27th of next year. For a constitutional amendment, it's slightly later. The deadline for that is July 6th of 2026. Now, for referendum, it's a little more complex. The right to referendum and the filing deadline is tied to when the legislature adjourns. Somebody who wants to do a referendum basically has up until 90 days after the legislature adjourns the session at which the law was adopted to file the referendum petition. Typically, the legislature adjourns in late December. And so on the PowerPoint, you see I put some approximate dates for the deadlines. For legislation enacted this year, somebody who wanted to do a referendum on that would have until approximately March 31 of 2026 to file. Again, they can file early. If you want to do a referendum on a bill the legislature has already passed this year, you can start now. You don't have to wait. But the deadline for filing those petitions would be roughly the end of March 2026. So we talked about the types, we talked about the signature requirements, and we talked about the deadlines. I just want to kind of give this kind of big overview before we delve into more detail about it. So on the next slide, I was also asked not only to talk about process, but also designing a petition drive, some of the considerations that will go into that. I want to put this slide second after I gave you all an overview of the process. So this design slide makes a little bit more sense. If you understand, we have three types, there are deadlines, there are signature requirements. So with that context, let's talk about what goes into a petition drive. One of the fundamental questions that has to be decided is what type of proposal. Obviously, if it's a referendum, you don't like a particular piece of legislation, then the obvious choice is a referendum. However, then you've got options. If you're looking at, say, amending a current statute, maybe you want to enact a new law because the legislature hasn't enacted it. Or maybe you perceive a problem with the Constitution, or you want to add something to the Constitution, and so maybe you want to think about a constitutional amendment. So one of the most important initial decisions is what type of proposal. And into that decision would be some of the things we just talked about. What are the filing deadlines? How many signatures do we have to collect? As well as the substance of what you want to put in. Is it a constitutional amendment that our Constitution has a lot of detail in it, but generally it's a document of principles, governing principles. Statutes, of course, are much, much more detailed, designed to apply the law in very specific ways. So sometimes that's a deciding factor, even though, again, there are some very detailed constitutional proposals. I think of two proposals that the league actually supported in 218 and 222 about voting rights. Those are very detailed. One of the reasons for that was to prevent the legislature from undermining those proposals by saying, oh, well, here's a gap. Here's something that's undefined. Here's some part of this process that the legislature could, undermine. And so I was one of the drafters of that, not the sole drafter by any means, but I helped draft it, those proposals. And so one of our considerations was try to make it tamper-proof, try to make it in a way that the legislature could not undermine it by defining terms or imposing its own procedures. So that's one reason why those two proposals are so detailed. So once you decide the type of proposal, then there's a lot of research that needs to be done. Obviously, you need to do legal research in terms of how you would draft a constitutional amendment, a referendum petition, a statutory initiative. Particularly for statutory initiatives, a lot of guidance from what the legislature does, because a legislative initiative is basically a bill. And so you would follow the procedures that the legislature would follow in drafting a bill. Constitutional amendments, there's no such model, but you obviously could look at the Constitution. For a referendum, much simpler. On that, on the back of the petition, you simply put the law that you want to have an up or down vote on. You don't have to do any original research, any original drafting, because you're asking the voters whether they approve of that piece of legislation. But for the other two types, statutory initiative and constitutional amendment, obviously, there's a lot of legal research I have to put into that. Now, part of the research process may include polling. Many groups, want to know before we spend millions of dollars putting a proposal on the ballot, trying to pass it, can it pass? And so in this process, people can afford it. It's not unusual to see polling being done as part of the early process concerning whether to do something, what elements it should include, polling can help you make those determinations down to the words that you use in the proposal. And so that, again, that's very, very common that you see polling as part of the research. And polling I use in a very big generic sense, could be focus groups, could be a traditional telephone poll, could be online research. There's lots of ways to conduct polling nowadays. So once you've made the decision, once you've done some of this initial research, then you would get down to draft the actual proposal, if it's a constitutional amendment or statutory initiative. And then you come, of course, to the petition drive itself. And I'm going to talk in more detail about getting it on the ballot in a moment. But big picture in terms of the drive, things like, are you going to be part of a coalition that's going to push this proposal? This is a very big state. 10 million residents, over 8 million registered voters. This is a big undertaking to put something on the ballot and get it passed. And so allies can be very, very helpful. And you got to think about who your opponents might be as well. Because it's could be a very expensive process, you need to think through from the beginning, budget. How much money are we going to need to spend to draft our proposal? How much are we going to have to spend to get it on the ballot? Are we going to have to pay for signatures? Or are we going to be able to use some volunteer to gather those hundreds of thousands of signatures? Where are we going to get that money? And in my experience, petition drives is very much a COD business, cash on demand. You can't say, somebody say to you, well, we'll give you $1 million in October of the election year. Well, if you're collecting signatures and paying for them, those firms and those workers demand payment immediately. They don't take CODs, or they don't take checks, they don't take IOUs. If you're running a petition drive and you're buying signatures, you are putting out significant cash every week. And so you've got to worry about not only where'd you get the money, but cash flow, making sure you have enough cash on hand to pay the expenses in these drives. Obviously, if you start a drive this year and it culminates in November 26th, you're talking about a year and a half. So you got a budget for all of that. Where are you going to get the money? How are you going to spend it? Campaign staff, printing petitions, paying circulators, whatever campaign you decide to do in the fall of 26. A budget is critically important. You really can't function in this process, or frankly, in any campaign and situation I've ever been in, without a realistic budget. And then finally, a calendar. And basically this is how we do it in politics. Everybody does this. You start on election day, in this case of 2026, and you work backwards, right? When would we do our TV ads, our radio ads, our mail, and so forth in the fall of 26, whatever the campaign will look like? When are we going to file our signatures so that we can get them approved by the state and get this on the ballot? And I'll go through some calendar items in a moment, but you basically start election day and work backwards until you reach the point where you've started your drive. And that way you've got a detailed plan. That'll also help you develop your budget, right? Because you see the plan, oh, we're going to pay for signatures for this 6-month period. When that means you need to have X amount of dollars during that period to pay all those circulators, et cetera, et cetera. So the budget and the calendar are very much interrelated items. And again, you can't do this on a wing and a prayer. You can't do a campaign based on hope. You have to have a realistic budget and a realistic, achievable calendar in order to pull off this kind of statewide effort. And they are massive. So those are some of the basic elements that need to be considered when you're designing a petition drive. Let's now turn back to procedures, back to process in terms of how this all works for a statewide proposal under Michigan law. And there are various steps here. once you have drafted your petition, and it's a form, basically, the front of the petition is 90% a form that's been developed by the state over the years. There is room on there to put your summary of the proposal. And of course, on the back is the proposal itself. The legislation you're proposing, the referendum or adopt, the constitutional amendment that you want to have adopted, that will go on the back of the petition. But then your first encounter with state government can occur at that point. In Michigan, the Board of State Canvassers exclusively has control over the ballot proposal process. In other states, Secretary of State has a role, the Attorney General has a role, governors sometimes have a role. In Michigan, they do not have a role. It's only the State Board of Canvassers. That is a 4-member bipartisan board. And again, one of its functions is to oversee this process. It does other things. It certifies election results. It oversees the approval of election devices in the state. But tonight we're just focusing on its role in this ballot proposal process. So it's a 4-member bipartisan board. It has developed, and this is actually in state law, a voluntary process in which it will pre-approve your petition form and the summary of your proposal on the ballot. As I mentioned a moment ago, the form is pretty much set by state law, but people can make mistakes. Right?
Excuse me, Mark, I'm very sorry, but I had left some of the security unchecked and somebody decided to deface your document.
Oh, sorry to see that.
Well, I thought I'd set all of the security correctly. I think it'd be best if I close the document and open it again.
Yeah, whatever you think is best. I'll stop my presentation until we try to correct this.
All right, Mark, we're on the 3rd page now. Is that where we should be?
That's where we should be. Thank you. So this voluntary process, let me just draw a contrast here. You can proceed with your petition form and the summary you draft without going through this voluntary process. The risk is that if you've made a mistake on the form or your summary is challenged later on as being inaccurate, it's possible the entire petition could get thrown out, even after you've spent millions of dollars collecting signatures. So this process offers a way to avoid those problems, where working with the board and its staff, the board will review your petition form. It won't review the substance of what you propose, but whether it's properly formatted, and it will actually draft the summary that goes on the front of the petition, the summary of the proposal. And then there's a hearing before the board in which supporters and opponents have a chance to be heard. The public has a chance to be heard. And then ultimately, the board votes whether the form is correct and to approve the summary. Now that requires a bipartisan majority vote. So if all 4 members are present, it takes at least 3. If there are only 3 present, and that's a quorum, it will take at least 2 votes, but it must be 1 Democrat and 1 Republican. So you have to have a bipartisan majority of the board to approve it. Now, the advantage of this process is that it prevents the problems I mentioned a moment ago. If you go through this process and your form is approved and your summary is approved, later on in the process, when you file your petitions, people cannot challenge the form of the petition or the summary. for being inaccurate. So it's kind of like an insurance policy. That doesn't mean there won't be challenges to your signatures or to the substance of your proposal, but at least you can avoid a challenge to say you got the wrong typeface size on your petition, or your summary is unfair, it's not accurate in some way. You can avoid those kind of challenges by going through this process, which typically takes a couple of months. I generally advise my clients to allow a couple of months to present their petition to the staff, work to make sure there's no errors. Then you ask a summary to be drafted, and then there has to be a board hearing. So it can generally take up to a couple of months. So that's, I think it's a good process that we have here in Michigan, and virtually all the petition drives I'm familiar with use it. There are some that don't. They've taken the chance, but for whatever reason, they decided they didn't want to use this process. Once you get the approval of the board on the summary and on the form, you then proceed to the circulation phase, which is the next slide. And again, this is typically done by volunteers or paid circulators. In Michigan, purely volunteer efforts have been very rare. Voters Not Politicians did it in 2018 for their redistricting proposal. In the past, the Catholic Church has done it with some of the right to life proposals, but purely volunteer efforts are the exception, not the rule in Michigan, simply because you've got so many signatures to collect. It's just very difficult to get this all done on time. We're now talking about, 500,000 or more, perhaps 600,000 signatures to get a constitutional amendment on the ballot. That would be an extraordinary volunteer effort. You all have probably all gathered signatures. You know how tough it is, particularly given Michigan's climate. And so again, typically we have paid circulators, and say sometimes supplemented by volunteers. Those are the two methods that are principally used. Circulators, whether they're paid or volunteer, need only be qualified to register to vote. It used to be that they had to be registered voters in Michigan. That was struck down correctly, I think, as unconstitutional. So again, all they have to do is be qualified to register to vote. The person has to be at least 18, right? But they may not necessarily be a Michigan resident at the beginning of the drive. There are groups, individuals who travel the country doing petition drives. And as long as they're in Michigan long enough to be qualified to register to vote, they can be a circulator. And we do have many out-of-state circulators that come into Michigan to help with petition drives. And there's a couple places on the petition form where they have to indicate that they are a paid circulator. The petitions have to be signed and dated in the presence of a circulator. You can't just leave the petition on a countertop or someplace for people to sign it. The circulator, by law, has to be there and witness somebody signing, and that's always a good idea to make sure it's done correctly. And finally, circulators must sign and date the petition attesting to compliance with the law. Now, these last 2 points, and Jennifer and the league asked me to address this, have been points where people have brought challenges. If you can provide evidence when a petition is filed that it was not signed and dated in the presence of the circulator, that would be a basis to throw out that petition sheet. I have brought challenges claiming that a circulator's signature was forged, that the name on that petition was not actually the person who circulated it. And of course, you have to write evidence of this. In terms of circulators signing and dating, if they fail to do that or they do it incorrectly, that could get tossed out. And also this concept I mentioned a moment ago, that perhaps circulator name was forged. In that case, of course, the signature and the date would be false. And so we've had challenges on that basis. And one of the advantages of bringing those kind of challenges is that if you're able to successfully challenge a circulator, that knocks out the entire petition sheet, right? And not just one signature, but the entire sheet. And if you've got circulators who have circulated a lot of petitions, you may end up with a situation where a lot of signatures could get tossed out if you can find wrongdoing by the circulator. So attacks on circulators, signatures, other things that they may have said which were untruthful, have become a real point of contest in this process. So once you have collected your signatures, and this is on the next slide, item 5, you file those petitions with the Board of Canvassers, and then the process proceeds as described here. Its staff selects a random sample of 1,000 signatures to review for validity. The state has never reviewed all the signatures. For decades, they have used some type of random sampling based on a statistical model. They would look at the sample, how many signatures are valid, and then they would basically project, based on statistical probabilities, whether the petition drive meets those signature thresholds that I mentioned at the beginning. It's all based on statistical probabilities. So they pick a random sample of 1,000 at this point, and they go through those signatures, and those signatures can be widely scattered, right? They're not going to be on the same sheet. So they're going to be scattered throughout, and they have a method that generates the random sample by petition sheet. They number all the sheets when they're filed by petition sheet and line number. So they go and the staff looks very carefully at that sheet for any defects in the sheet, but also looks at the signatures. Was it correctly signed? Were all the lines correctly completed? Was it dated by a registered voter, et cetera, et cetera? So there's lots of things they go through. And they also look at the petition form. You know, you may recall on petition forms now, they're circulated countywide. You're supposed to put the county in the top of the form. If you don't do that, or you put a different county from where the signers live, that's a basis to challenge the sheet or particular signatures on that sheet. So they look at the form on which that sampled signature is found to make sure that that form was properly completed and filled out. Now, a very important rule here in Michigan is that all signatures must be dated within 180 days of the filing date. So it's kind of a rolling period. What happens is on the date you file, when the Bureau pulls that sample, they will automatically throw out any signature that's more than 180 days older than the filing date. Petition drives in Michigan are very conscious of this. I personally think this rule is unconstitutional. And I've been looking for cases to challenge it. I think it's too short, particularly given the Michigan climate and the volume of signatures that have to be collected, but it's currently the law. And so this very much affects the calendar of a petition drive, right? Because you know, if you start collecting and you get to the 7th and 8th month, you're going to start losing signatures that you collected in the first month or two. So part of the planning for the petition drive is when's the best 6 months for us to do this without losing signatures on the back end and getting it timely filed on the front end. Typically in Michigan, people start their petition drives early in the new year. Bad weather, that does give you into the spring and into July if you're doing a constitutional amendment. But increasingly, people have figured this out, and they now do their petition drives in the off year. You know, for example, if you were to start a petition drive now, you would have all the summer months, good weather to collect, including into the fall, including, in this case, November municipal elections, which would be a great opportunity. And you can file them this year and avoid the bad weather and the crunch that occurs in the spring of an election year. A couple of recent petition drives did this. Voters Not Politicians did it. The marijuana legalization proposal a few years ago did it. And there are advantages to it. Obviously, you have to plan ahead and get started so you can be ready to hit the streets when the good weather of the off year hits. But there's a lot of advantages to that if you're able to plan ahead, raise the money, and do what's necessary to do it in the off year as opposed to spring of the even year. So back to this process. So the sample is pulled, the staff starts to review it, but individuals and groups can also get a copy of that sample and challenge those signatures. And again, this is very common. I've done this many times, not just for ballot proposals, but for gubernatorial and other campaigns. And the group that does this, you have a crew of people and you systematically go through the sample and basically mirror the process that the staff goes through. They publish a list, the state does, of all the things they check for. Well, you would use that same list to go through all the sampled signatures, including whether they're registered voters. That process could also include examination of the circulators, right? Did they fill out the circulator information correctly? Did they date it? Did they sign it? Are there defects in the circulators of the sheets that are part of the 1,000 sample? And so all that gets fed into the process. You file your challenge, and the staff considers that as they do their own review. And then ultimately, the result of all these reviews yield a staff report where the staff details what it did, it details the results of challenges that received, or they agreed or disagreed with them. It's a written report. And they make a recommendation to the Board of Canvassers. Should the proposal be certified for the ballot or not? And the board makes a decision at a public hearing at which people can speak pro and con. They can agree or disagree with what the staff has recommended. But ultimately then, the board has to have a bipartisan majority vote to put something on the ballot. A tie vote does not put something on the ballot. It has to be a bipartisan majority vote of the board that there are enough signatures and there are no other defects which would cause the petition to be rejected. Now, those decisions about the board decisions about putting it on the ballot or deadlocking even can be appealed to the Michigan Supreme Court. And there have been times when that court has overturned putting something on a ballot, or they told the board that you deadlocked when you shouldn't. You should have put that proposal on the ballot, and they order the board to do so. One final wrinkle to this process: Michigan is somewhat unique in the country in that our initiative process mandates that once it's certified for the ballot, the legislature has 40 days to consider whether to adopt an initiated law. If it rejects it or it doesn't do anything, it goes to the ballot. But it has to run this 40-day gauntlet in front of the legislature. The calendar that I laid out earlier on the first page of the PowerPoint, that date of filing for a statutory initiative takes that 40 days into account, that the filing deadline is early enough that after the process is complete and a proposal has been certified, there's still sufficient time to give the legislature its 40 days and still put the proposal on the ballot. It's tight, particularly if there's lawsuits, but it can be done. So that's a little wrinkle. Michigan's initiative process is actually called indirect initiative because the legislature still has this opportunity to adopt a proposal. If they adopt it, it doesn't go to the ballot. So that's one of the pluses of that process. Some of you may recall, we just went through a major lawsuit on this where the legislature adopted a proposal to keep it off the ballot, and then they gutted it in the subsequent lame duck. We got the Michigan Supreme Court, fortunately, to say that that's illegal last summer, that you either have to adopt it and let it be, or reject it and let it go to the voters. You can't adopt it and then take it apart. That is wrong under our constitutional scheme. So the next phase then is your proposal's been certified for the ballot. Sometime, this would, when, no matter when you file, this would probably occur in the summer of the even year. Might occur earlier, but usually in the summer. But then we come to, okay, what's going to be on the ballot? Now, Michigan, unlike some states, does not put your entire proposal on the ballot. You can only imagine how long our ballots would be if we had to do that. They're already long enough, Michigan ballots. And so, historically, what we've done is that we put a summary, 100-word summary on the ballot. That summary is prepared and adopted by the same Board of Canvassers. But there's a process there where supporters and opponents have an opportunity to have input. They can submit their own proposed summary, they can criticize somebody else's, and ultimately there's a hearing before the board. And the board, by a bipartisan majority, adopts a summary. Its decision in this regard can also be appealed to the courts. I've seen where a court has overruled the board and ordered them to adopt a particular summary that the board either headlocked on or did not adopt. But there's always recourse to the courts for this summary process. And the summary process is very important because we all know many voters do not read the proposals. Maybe they'll read some campaign literature or see a Facebook post or something, but most voters are going to get their information from that 100-word summary. So what's in that summary is really important to the supporters and the opponents. And we have had some major battles over what's in the summary because it can have such an enormous impact on whether the proposal passes or not. So then, once you have a summary, goes on the ballot, and you have the election, and the Board of State Canvassers again, along with all the other election results, certifies the election results. This typically occurs in late November of the election year. But then again, if somebody is dissatisfied with the results, they can ask for a recount, partial or complete, of the statewide results. These are rare in my experience, ballot question recounts. We had a couple in 2022. But again, they're rare, but people have the right to seek a recount of the votes in a ballot proposal if they're dissatisfied with the result, and they can show grounds for why the recount might change the result. So that's the end of the PowerPoint presentation, along with my verbal elaboration. I think we still have some time, and I'd be glad to field questions if that's all right with our hosts.
Sure it is, Jennifer. And I kind of, did you have anything before we talk about questions?
No, I tried to capture the questions too.
Oh, great, thank you. One question, and there were some before it, and I'll get to those, but Caleb was talking about, does this mean that there are no allowable methods of digitally collecting petition signatures?
That's correct. These have to be what we've come to call wet signatures by a person in person signing the petition. No electronic signatures, no signatures by people who are guardians or conservators. I've seen that on petitions over the years saying, I'm the guardian of this person. I have the power of attorney. Those are invalid signatures. It has to be the signature of an actual registered voter.
Okay, if you need more information on that topic, if you're the questioner, let us know, and you could maybe directly ask that. Another question is there any mechanism through which a bad actor could request to review the full set of collected signatures, even though boss BOSC only reviews the statistical sample, is there concern of oppositional efforts with a lot of funds looking through 100% of signatures in order to find grounds to challenge?
Right. Well, certainly somebody could do that. They can request, it's basically an FOIA request, copies of all of the petition sheets. You may have trouble getting them timely. That's a lot of data. Requires a lot of scanning, and some groups I know actually send their own people and scanners into the Bureau of Elections, supervision of the staff, scan all the sheets themselves. That's been known to be done. It's very expensive. But the problem you're going to have is if you do that, the Bureau by law is still going to depend, and the board, on that sample. They're going to make the determination based on the sample. So you're going to have to come up with something extraordinary outside the sample in order to raise doubts. And maybe you detect a pattern of massive fraud. And you try to bring that to the attention of the board. But again, it's going to be very difficult. We had a switch here recently on the candidate side, which I'll explain. In 2022, when it came to candidate petitions, the board and the Bureau did review every signature. And so Cheryl was not common, but it happened. I've done it, where all the signatures were requested for statewide candidates. There's a lot less of those, right? It's 15 to 30,000, much more manageable than a ballot proposal. But in 2022, I and others requested all of the signatures for several candidates, and we proceeded to go through them, looking for patterns of fraud, which we found and raised them. Since that time, though, the board has switched to sampling for candidate petitions as well. So what I and others did in 2022 is no longer really an option. If you're going to allege some kind of pattern of fraud or something else like that, you're going to have to find it inside the sample in order to get anywhere with the board.
That was interesting. Let me go down to, let me see, I'm sorry.
Phelan and Caleb Phelan had an earlier question and Caleb answered it. Did you capture that?
It was something about statistics. It said, she was looking for specific statistics and he answered that.
Well,
I
Phelan
believe-
asked for the ballot proposal signature requirements. How are the number of required signatures for each type determined?
Right. I didn't put that in the presentation, but they're in the Constitution. For a constitutional amendment, the formula is 10% of the most recent gubernatorial vote. And if you crunch the numbers, you'll find that 10% number yields 446,198, the number I put in the PowerPoint. And that's why the number switches. After every gubernatorial election, these numbers are going to change because they're tagged to the turnout. It's 10% for constitutional amendment. It's 8% for statutory initiative. That's why that number is a little bit lower. And it's 5% for referendum.
That's of the governor's vote, the vote for governor, all
Yeah,
of that.
the total vote for governor, all candidates, total vote.
Then if a percentage of the sampling is bad, this by Patricia, when does the board eject the petition? What is that percentage?
Right. Well, it'll vary from petition drive to petition, and I'm no statistician, but documents are publicly available on the board's formula and how it applies it. It generally, as you can imagine, again, I'm no statistician, but if you file a lot of signatures a smaller percentage would have to be valid in order for the entire drive to be valid, right? And so, you know, if you file 1,000,000 signatures, but you only need 500,000 valid ones, then if half the sample is valid, your petition drive is going to be valid. I'm grossly oversimplifying, and I don't want to offend any statisticians in the audience. So one of the reasons that people file a lot of signatures is to, you know, create a cushion for themselves, that they can withstand a lot of bad signatures and still qualify for the ballot. On the other hand, if you need 446,198 valid signatures to get a constitutional amendment on the ballot, and you only file 460,000, I can guarantee you're not going to make it. You're not going to make it. There's going to be way more invalid signatures, and the statistical projection is not going to be in your favor.
Okay, I'm not seeing some new ones here. I had some questions, but I think maybe if we see if, do people have questions, and can they ask those directly, Jennifer?
All right, we've got a couple of other questions that have just come up.
Okay,
If I may, I'd like to let these two people unmute themselves.
who are you looking for?
Phelan and Mary Jo.
Thank you. First, Mark, this has been a fantastic presentation, so thank you for presenting today and for your hard work on preparing the materials that you provided. My question, I may have misinterpreted, but it looked like on your materials that there was one of the final slides noted that after the signatures were collected, that the BOC had to still vote in order to put the proposal on the final ballot,
Yes.
and that had to be. So has there historically been any case in which a proposal collected a significant margin more than the minimum required, but failed that vote and was therefore rejected from the ballot?
Well, that could happen in a couple different ways, right? The staff could come back and say, you don't have enough signatures. And unless the supporters rebut that in front of the board would accept that report and probably on a bipartisan basis saying, you don't make it. I've seen that happen. It happened to one of my clients one time when they didn't file enough signatures. They were too close to the minimum. And I warned them. And unfortunately, my warning came true. Thus, they didn't have enough signatures. On the other hand, you could have a report come back that says there's enough signatures here and we should certify or not certify it. Or let's say certify it. There's enough signatures here, we should certify it. And unfortunately, sometimes, usually for partisan or ideological reasons, you may not be able to get a majority of the board to certify. And that's when the supporters go to court. And they say to the court, the staff says there's enough. There's no evidence that there's not enough. Order the board to certify. And generally, in my experience, the courts order the board to certify. Is that responsive to your question? I hope it is.
Yes, that's a perfect response. Thank you.
The other thing, when this most recently happened, it may have happened with reproductive choice, even though I know there was a court case over the ballot summary that the board deadlocked on the ballot summary. I don't think they deadlocked on signatures. That would have been highly unlikely, since and I was part of that drive, as probably some of you were, filed nearly 1,000,000 signatures. So the odds were that we had enough signatures, and we did.
Thank you. Deborah, I'm going to ask you to unmute.
Hello, hello, Mark.
Hi, Deborah.
Yes, I just wanted to ask, do you remember when you were the speaker for the our conference, League of Women Voters, MI? You were our keynote speaker, got a standing ovation, I must say. Do you remember what you spoke on and why you picked the topic?
I think I was asked to address the topic of threats to elections in general. That was a couple summers ago, so you're taxing my memory, Deborah.
All
Uh,
right, good. Welcome to the club.
Yeah, it was it was a great opportunity. I was honored to be asked. I think that's what I spoke about. But I do remember your national president at the end saying, Mark, what's the most serious threat? And I said violence. And I still believe that.
Okay,
Sadly.
thank you.
Thank you, Deborah.
Do we have any more questions from the
Yes.
audience here?
Caleb,
Okay.
I'm asking you to unmute.
Yeah, I was just kind of just expanding on what you were saying, Mark. First off, Mark, thank you for the presentation. It's been really good. I know we appreciate it. I guess what I'm hearing is that with the board of canvassers, with the certification of these, of the signatures, that there is a bit of an element of maneuvering outside of just the pure numbers game. I mean, is that a correct characterization? I mean, there are scenarios where these could be not certified when there are objectively enough signatures, or vice versa, with a little bit of partisan wiggle room.
All right. I mean, people can criticize our system here, particularly our board of canvassers. They do deadlock. In my experience, the courts generally have been fair in terms of doing the right thing in that situation. But I contrast that with other states where the decision on certification is in the hands of one partisan. Maybe it's the Secretary of State, maybe it's the Attorney General. I think that's worse. At least here in Michigan, for its faults, we have a bipartisan, transparent, public process. Where everybody can watch these hearings, they can see the reports, they can hear the arguments, see the analysis. So all the way through the process. And also, I'll add, in my experience, the state staff that works for the board is nonpartisan. They are very professional. I don't always agree with their decisions, but they're not partisan. They really do try to do the right thing. So it's a long-winded answer, Caleb, I'm sorry. But for all of its defects, and partisanship does come in, and ideology does too. I think on balance, we have a very good system.
Well, thank you.
And Phelan had a comment. Would you like to unmute?
Oh, I'm not sure I had anything else to add.
No, you were answering Caleb's question.
Yes.
No. But if
do
you
you
don't
want me
have
to
more than
say that
that,
answer out loud? No, that's I could leave it at based on Mark's response about the Board of Canvassers' final vote and the potential need for court intercession. It is important to know, and it had never occurred to me when planning statewide initiatives, the potential for needing the networking aspect or the people aspect to ensure that you don't have bipartisan opposition, which hopefully is a very rare case that somebody could get the requisite number of signatures and still have bipartisan opposition. But it's good to know that that possibility is there.
well,
I
thank
just,
you, Phelan. Did
Have
anyone
one
else have a question or a comment?
I have one, Jennifer, if I can. I just wonder, is there any issue or concern that there would be some kind of issue that cannot be put up, any issue or concern that can't be put in up on a petition drive?
Yeah, there are a couple limitations. I didn't talk about those tonight. I had to make some editorial judgments. So when it comes to referendum, you cannot do a referendum on an appropriation bill. Right? And I think you understand the rationale for that. That would create chaos in the budget process if somebody could put a budget bill up for adoption. Unfortunately, that exception has also been misused. About 20 years ago, the Michigan Supreme Court said, well, appropriation means any amount of money attached to any bill. And so what we've seen the legislature do, and I hope we get this fixed someday, is they'll pass a huge policy bill and appropriate $1,000 to implement it. That makes it immune to referendum. I think that's unconstitutional, certainly contrary to the spirit of referendum. That appropriation exception was designed for budget bills and budget bills only. So that's one exception. On statutory initiatives, as I mentioned, they're like bills. So you're subject to the same restrictions that a bill is subject to, i.e. one subject, right? You can't mix utility regulation with campaign finance and those kind of things. It has to be one topic, one subject. And finally, on constitutional amendments, and we've had some fights over this that I was part of. If your constitutional amendment, I'll just say this is too broad, you may run afoul of the provision that says revisions of the Constitution can only be done by a con. This was a challenge that VNP encountered in 2018 when they wanted to do redistricting reform, and the Supreme Court rejected that. Said, no, this is redistricting. It's not a general revision of the Constitution, so we're going to let it proceed. But that is a limitation on what you can do with constitutional amendments. So yes, Cheryl, there are some of these limitations that you have to be conscious of when you do this. Good question, by the way.
Well, thank you.
Oh,
I've got a few closing notes.
can I ask one other question, please?
Certainly.
Okay, thank you. I know I was kind of reading broadly today on the internet for the good or the bad. And so reading about some of the voting bills that are coming up, but I was wondering how would the state, how does our state, do you know, independently verify one's citizenship? I mean, if that bill comes into being, I mean, but I know this is going to be on a petition drive, but I assume at some point in thinking about a petition drive, you have to think about all the things ahead that could happen, either in losing the petition drive or in gaining it, and prepare for those kinds of things. So
there are now two petition drives which would impose a citizenship verification requirement. You already have to be a citizen to vote, and you check a box when you're registered, I'm a citizen. These two drives would say, that's not enough, you got to bring a document, a birth certificate, a passport, something like that. And one of the proposals even specify what document. But in both those proposals, Cheryl, it says the Secretary of State shall set up a program to establish someone's citizenship, but it leaves all the details to the legislature and to the Secretary of State, which I think is very dangerous because it could be really abused to disenfranchise folks. So the honest answer is, Cheryl, as we sit here, we don't know. That if one or both those proposals passes, there'll have to be a lot of legislation to implement the Secretary of State's audit, inspection, review process, whatever you want to call it.
okay, thank you.
Well, thank you. I think that's all of the questions. Thank you very much, Mark. It's been very informative. This program should be available on the League of Women Voters YouTube channel and the Detroit Public Library's YouTube channel for the League of Women Voters programs. The link is here. I'm sorry, I've got to change this. I don't seem to have a way to do anything other than send a message. Here we go, to Cheryl. Here is the link to the collection of League of Women Voters recordings from the library. And In June, on the 10th, we have a program on direct democracy. Here's the link to register for that. If you have any questions or any suggestions about future programs, feel free to get in touch with me. I'm putting my email address in here. And again, if you would like to be notified individually of these programs, let me know.
Jennifer, can
And
I?
the League of Detroit website is here. Thank you very much, Mark. Thank you, everyone, for coming.
Yes, can I say one thing? We have our programs that are planned ahead for one. We will in October have Sheila Cockrell has agreed to talk about the city council and what the role of the city council is and what the responsibilities and the qualifications are for that. And since she's been a city council member, I think that will be very, very good. And we're I think in July, do you remember, Jennifer? I was trying to look for that. I mean, we will have this up on the line so you will know ahead, but we have some good programs planned. Mark, this was exceptional, so I appreciate so much you doing it. We all do, I think.
Well, thank you for asking me. Thanks to the League of Detroit and to the Detroit Public Library. Thank you.
May I ask just one more question? We have 2 minutes or 4 or something till 7:30. And that is, how in the world do people fund this? I realize, I know you don't have any secret people you're willing to share with us on that, but to fund something like this, it requires, it sounds like 4 or 5 huge donors and the backing of whatever the organization has in the national level too, even maybe. So is it a funding source that comes from both national and local and city and individuals? I mean,
Yes, it's usually a mix depending on the issue. I mean, I'll just tell you right now, the going rate for paid signatures as we sit here is $10. So just do the math. If you need 700,000 signatures to get a constitutional amendment on the ballot, that's $7 million. And that's just the signature cost. Obviously, you can reduce that if you have volunteers. And the signature costs go up. In last cycle, people were paying $15-20 a signature close to the filing deadline. It's a market, right? People are desperate for signatures, they have to pay more. So if you know, we're a big state, we've had high turnout elections, which is a wonderful thing, but also makes these numbers go up in terms of getting on the ballot. And so, yeah, these have become very expensive. Many of the proposals over the last several years saw tens of millions of dollars spent. I think the reproductive freedom one was an example of that, and all that was publicly reported. But I'm sure it was tens of millions of dollars spent getting that on the ballot and passing it.
democracy's expensive.
It can be. Now, on the other hand, if I may, Cheryl, VNP, they put their proposal on the ballot entirely by volunteers. They had volunteers that wrote it. Their budget was pretty low, and then people gave them money to get it passed, right? So, I mean, for what they achieved, very cheap.
Yeah.
But that
Cheap
is
and money.
that is an unusual petition drive to have that extent of volunteer.
Thank you.
Great, thank you. Are you ready to say goodbye? Thank you very much, Mark. And thank you,
Bye,
everyone else. Bye.
So much.